Welcome to Module 8 of the GRR Technical Training Series. Module Aim and Reminders. This module discusses permitting of radioactive waste disposal on decommissioning nuclear sites and surrender of permits to achieve release from radioactive substances regulation. This is the 8th and final GRR Technical Training module. Before we discuss the topics of permitting and surrender in more detail, it is worth just reminding ourselves about a few basic points. The GRR stands for the Management of Radioactive Waste from Decommissioning of Nuclear Sites, Guidance on Requirements for Release from Radioactive Substances Regulation, which was published in July 2018. The guidance is available on the SEPA website and can also be accessed via a summary on gov.uk. We use the term Radioactive Substances Regulation to cover the relevant legislation, which is different in Scotland from that in England and Wales. Although the legislation differs in detail, it shares common aims. We have written the GRR to fulfil those aims. Finally, please remember that the GRR applies to all stages of a nuclear site's life cycle and that all the requirements of the GRR need to be addressed for the final surrender of a site's permit. Terminology. The GRR uses the phrase release from radioactive substances regulation to describe the act of surrendering a permit. This phrase was adopted to reflect the different terminology used in the Radioactive Substances Act of 1993, which applied in Scotland at the time of publication, and the Environmental Permitting England and Wales Regulations 2016, or EPR 16, that applied in England and Wales. Since publication of the GRR, the Environmental Authorisations Scotland Regulations 2018 have come into force, and this has aligned terminology in Scotland with that in England and Wales under EPR 2016. All regulations now refer to surrender of a permit. Therefore, this training module uses the term surrender to describe the point at which a permit comes to an end and the site is released from radioactive substances regulation. The GRR uses the term site reference state to describe the state of a site that is suitable for a permit to be surrendered. Where the site reference state is achieved as soon as all planned work with radioactive substances is completed, then a period of validation monitoring will normally be required before the permit can be surrendered, as shown in diagram A in this slide. Where the site reference state is achieved after a period of control for the purposes of radiological protection, we expect that validation monitoring will take place during the period of control. In this case, the permit can be surrendered as soon as the site reference state is achieved, as shown in diagram B in this slide. Why permitting and surrender? At first glance, it may seem a bit strange for guidance that is about the surrender of a permit to also talk about permitting. So why do we have this apparent conflict in the GRR? In order to bring a site to a condition where the permit can be surrendered, it may be appropriate for some radioactive waste to be managed on the site, where this can be shown to give the best overall environmental outcome, while also complying with the radiological protection standards. If the best outcome is to manage radioactive waste on site, legally this would constitute a disposal of radioactive waste. Such a disposal would therefore need to be authorised, and an operator's permit would need appropriate conditions to allow the disposal activity. In such a case, the permit for the nuclear site could only be surrendered after an appropriate variation to allow any on-site disposals that are part of the plan to achieve the site reference state. For clarity, it is worth stating that if the best options for managing radioactive wastes on a particular site do not include any on-site disposal, then there will obviously be no need to vary the permit prior to permit surrender. Radioactive contamination that the operator decides to manage on-site is not legally a disposal of radioactive waste and so is not permitted. It does, however, need to be fully considered in determining whether the permit can be surrendered. Standards. The environment agencies have duties to protect people and the environment from the harmful effects of ionising radiation. We do this on nuclear sites by permitting the disposal of radioactive waste either on or from the site. Permitted disposals of radioactive waste are only allowed where an operator can demonstrate that our standards can be met. In the GRR, numerical standards are set for the period when an operator is carrying out a regulated activity and for the period after all controls over that activity end, as illustrated in the figure. These standards originate from the Environment Agency's guidance entitled Near-Surface Disposal Facilities on Land for Solid Radioactive Wastes, Guidance on Requirements for Authorisation, known as the Near-Surface GRA. When disposals of radioactive waste are authorised, we need to consider the post-closure period and what happens to the disposed waste far into the future to ensure risks to people and the environment are acceptable. The same standards are applied when considering whether the permit for the site as a whole can be surrendered. The standards of decommissioning and cleanup must be sufficient to protect people and the environment in the long term to an equivalent degree to that which applies for the disposal of radioactive wastes. The combined impact of any on-site disposals of radioactive waste and contamination managed on the site must collectively meet the standards of protection specified in the GRR. The Waste Management Plan and SWESC need to show that the dose constraints, that is requirement R9, can be met during the period of regulation. After the period of regulation, the risk guidance level, that is requirement R10, must be met for the totality of radioactivity remaining on the site, and the dose guidance level, that is requirement R11, must be met for each individual disposal. Both of these numerical standards must also be considered in relation to any potential natural disruptive events that the site may be subjected to as it evolves. See requirement R12. These numerical standards are explained in detail in Module 5, Understanding the Numerical Standards. On-site disposal options. Let us now look at the possible on-site disposal options for radioactive waste from the final stages of decommissioning. This slide shows the on-site disposal options that are included in Figure 5 of the GRR. For consistency, the option numbers are those from the original figure. While this training module illustrates the potential on-site disposal options, it should always be remembered that on-site disposal will only be permitted if it is shown to be the best option for managing a particular radioactive waste stream. The disposal options are shown here in 3 groups. This is because they each have different implications for permitting of the disposals. First, I will briefly introduce the groups, and then we will come back to the permitting issues. Option B illustrates a dedicated disposal facility. This is an on-site engineered facility where solid radioactive waste is permanently emplaced solely for the purpose of disposing of that waste. Options C and D illustrate in-situ disposal. This is where radioactive waste below the ground surface is left permanently in position. In-situ disposal applies to redundant structures that are waste, such as buried pipework and foundations. Options E, F, and G illustrate disposal for a purpose. This type of disposal is where a permanent deposit of radioactive waste is made as a replacement for other materials that would otherwise have to be found for that purpose. Now that we have reviewed the broad types of disposal option, let us consider the implications for permitting these disposals. Permitting of on-site disposals, common issues. Firstly, there are a number of common issues that apply whichever on-site disposal option is being considered. Operators must be authorised before they can dispose of radioactive waste on site, whether by emplacing waste or leaving it in situ. If an operator's waste management plan concludes that an on-site disposal is appropriate for managing at least one waste stream, the operator will need to apply for a permit variation to authorise the disposal. While it is up to the operator to decide when to apply, we encourage early applications. The GRR is designed to ensure that all proposed on-site disposals identified in an operator's waste management plan are considered as a whole. Ideally, an operator would make a single application for all proposed on-site disposals. However, in practice, this may not be possible, for example, if changes are made to the waste management plan. We encourage operators to minimise the number of separate applications. applications for variation for on-site disposals must be accompanied by a waste management plan to demonstrate that any proposed disposals are optimal for the particular wastes, and by a SWESC to demonstrate that the disposals will be safe. The SWESC should also demonstrate that the level of protection against any non-radiological hazards arising from the proposed disposal is equivalent to the protection provided by the relevant national standards for non-radioactive waste. Now we will look at specific permitting issues associated with each type of on-site disposal. We discuss in-situ disposal and disposal for a purpose first because we anticipate that development of on-site dedicated disposal facilities will be relatively infrequent. Permitting in-situ disposals. Operators must be authorised before they can dispose of radioactive waste on site, including when leaving it in situ. Even though for in-situ disposals there is no physical act of emplacement of radioactive waste, authorisation must be obtained before the disposal is legally recognised. For buried infrastructure, the operator will need to consider whether to dispose of it in situ, and if so, how to do that, or whether to retrieve and dispose of it in some other manner. Their assessment of the optimised disposal options must be timely, and the operator should set out their intentions in the waste management plan at the earliest opportunity. With in-situ disposal, there may be difficulties in clearly defining the act of disposal and its timing, and this may make it difficult to decide when an application for authorisation should be made. We recommend that operators discuss this with the relevant environment agency. The application for a permit variation should be made as soon as reasonably practicable, especially where a site's decommissioning programme includes a quiescent period where waste may stay in the ground for many years. Operators should be aware that where there is uncertainty about the status of redundant subsurface structures on a nuclear site, we may conclude that the operator has disposed of waste in situ if they have not declared any intent to retrieve the waste in the waste management plan, or the declared intent to retrieve the waste is unfeasible, or we believe it is unlikely to be implemented. For subsurface wastes, where an operator plans to make use of radioactive decay to facilitate eventual disposal, this must be declared in the waste management plan. The operator must have a credible plan to retrieve and transfer the waste for disposal at another authorised facility within a reasonable time. If an operator has no credible plan to retrieve and dispose of the waste off-site, we might regard this as a de facto decision to dispose of the radioactive waste in situ. This is particularly relevant where a site's decommissioning programme includes a long quiescent period. As soon as a decision is made to dispose of a redundant structure in situ, an application should be made to authorise that disposal. Permitting should not be delayed to take advantage of radioactive decay in these circumstances. Permitting disposal for a purpose. An operator may apply for authorisation to dispose of radioactive waste on site for a purpose, such as making land safe by filling voids, constructing roads, tracks and hardstanding, constructing bunds, barriers or screens, and landscaping to comply with local planning authority requirements. In these cases, the operator must be able to show that the waste has suitable physical and chemical characteristics for the particular purpose. Any works must be done in accordance with relevant legislation and must apply good engineering standards and good practice. Even though the radioactive waste is being used as a suitable replacement for clean material in carrying out the specific purpose on a decommissioning nuclear site, it remains radioactive waste. As such, its deposit is a disposal that needs to be authorised. In the situation where the void is a contaminated below-ground structure being disposed of in situ and backfilled with suitable radioactive waste, the permit application should be made for the whole disposal system. That means the structure and infill together. In this case, the permitting approach will follow the one for disposal for a purpose, taking account of the contribution that the contaminated structure makes to the total inventory of radioactivity. Two separate applications are not required. Permitting an on-site dedicated disposal facility. A permit application for a dedicated disposal facility should be made in accordance with the Near Surface GRA. The Near Surface GRA requires an environmental safety case, or ESC, to be prepared to demonstrate the safety of the facility both during operations and after closure. The operator should take full account of the risks assessed in this facility-specific ESC within the SWESC for the site as a whole. Other permitting considerations. This training is focused on radioactive substances regulation. However, it is important to remember that other legal obligations apply to nuclear sites, and these will also need to be complied with. While we do not attempt to describe them all here, we want to draw attention to the most relevant ones. Firstly, we will briefly consider other environmental regulations, including those relevant to groundwater, protection of the water environment, and directive waste. Where radioactive substances could enter groundwater as a result of a disposal of radioactive waste, the requirements of the groundwater protection legislation have to be delivered through the radioactive substances permit. Further information about how we consider protection of groundwater can be found in Module 4 on the site-wide environmental safety case. When thinking about the wider protection of the water environment, separate permitting may be required if operations on a nuclear site involve activities such as water abstraction, water impoundment, watercourse engineering, and discharges to surface waters. In England and Wales, the relevant legislation is the Water Resources Act 1991 and EPR 2016, and in Scotland, the Water Environment Controlled Activities Scotland Regulations 2011. Operators should ensure that they comply with the relevant provisions when embarking upon any activity covered by this legislation. Operators will need to ensure that any waste that is not radioactive waste, known as directive waste, is managed in accordance with the relevant regulations. Regulations across the UK that govern non-radioactive waste transpose the EU Waste Framework Directive. This directive concerns the collection, transport, recovery and disposal of directive waste. It requires all member states to take the necessary measures to ensure directive waste is recovered or disposed of without endangering human health or causing harm to the environment. DEFRA and SEPA have published guidance on the legal definition of directive waste and its application. Although the GRR includes considerations of the non-radioactive properties of radioactive waste, the GRR does not extend to requirements for non-radioactive waste streams. Activities involving non-radioactive wastes on decommissioning nuclear sites may require separate permitting. We encourage operators to take an integrated approach to the management of both radioactive and directive waste, especially during final decommissioning of a site. In addition to UK regulations, there are also international obligations that might apply when disposing of radioactive waste on site. In particular, Article 37 of the Euratom Treaty requires that each member state submits information to the European Commission about any plan for the disposal of radioactive waste. This is to enable the Commission to give its opinion on whether implementation of the plan is liable to result in radiological contamination, significant from the point of view of health, in another member state. After the UK leaves the European Union and the Euratom Treaty, similar arrangements are expected to be put in place for the consideration of transboundary impacts. Given the long lead times for such permissions, we recommend that operators determine the need for an Article 37 submission as early as possible in planning for any on-site disposals of radioactive waste. Interactions with ONR and Planning. While the environmental permitting of on-site radioactive waste disposal is a matter for the environment agencies, this is not done in isolation of other regulatory requirements. In particular, the regulations governing the safety of workers, the security of nuclear material, and land use planning all interact with environmental regulation. The Office for Nuclear Regulation is responsible for safety and security on nuclear sites under the Nuclear Installations Act 1965 and grants nuclear site licenses to operators. In addition, the Office for Nuclear Regulation plays a role in assessing the environmental impact of nuclear reactor decommissioning. This responsibility ensures that the environmental impacts of decommissioning nuclear power stations and nuclear reactors are assessed prior to the commencement of any decommissioning work. This duty is enacted through the Nuclear Reactors Environmental Impact Assessment for Decommissioning Regulations of 1999. The Environment Agencies and the Office for Nuclear Regulation have produced a joint document that describes how we will work together to achieve a harmonised approach to the regulation of on-site disposals of radioactive waste made under the GRR. This document is known as the Joint Statement of Common Understanding on Disposals of Radioactive Waste by Deposit or Burial, and can be downloaded from the SEPA and ONR websites. Finally, any proposals for managing and disposing of radioactive waste on a nuclear site may require planning permission under the Town and Country Planning Act 1990 in England and Wales, or the Town and Country Planning Scotland Act 1997 in Scotland. The land use planning system is separate to and independent of radioactive substances regulation. While the agencies consult the relevant local planning authorities on permit applications, and they consult us on relevant planning applications, the two processes are independent. Permit surrender prerequisites. We have spent a large portion of this module talking about the permitting of radioactive waste disposals. However, it is a primary aim of the GRR to set out the standards that a nuclear site must meet to enable the permit to be surrendered. While the detailed application process differs between Scotland and England and Wales, there are two key prerequisites that must be met before a permit can be surrendered. They are, firstly, all disposals of radioactive waste on or from the site must have definitely ceased. And secondly, the site reference date must have been achieved. Let's look a bit more closely at each of these prerequisites. Definitive cessation of radioactive waste disposals. Radioactive substances activities will have definitely ceased only when all activities involving the production, receipt or disposal of radioactive waste have permanently ended. This includes any disposals arising from the cleanup of any radioactive contamination. There must be no waste on site awaiting disposal, either for on-site disposal or transfer off-site. For sites where decommissioning is deferred by a period of care and maintenance, definitive cessation can only occur at the end of final site clearance after the care and maintenance period. The Waste Management Plan should provide a demonstration that this condition is fulfilled, as all planned activities involving radioactive substances should have ceased on completion of the plan. Achieving the site reference date. For the second prerequisite, the site reference date is achieved when the SWESC shows that the residual risks presented by the radioactive substances remaining on site, if any, are consistent with the risk and dose guidance levels. These are described in requirements R10, R11 and R12 and are the subject of Module 5 in this training series, Understanding the Numerical Standards. The risk and dose guidance levels must be met without the need for controls by the operator or any other body. In order for the site reference date to have been achieved, the operator must demonstrate that the site as a whole will meet our protection standards. The SWESC should provide this demonstration by taking account of all relevant sources of radioactive substances and potential receptors. Full and partial surrender. Operators may apply for surrender of all or part of their permit for a nuclear site. We expect the operator to apply only when the site, or part of the site, is close to achieving the reference date. If an operator applies for partial surrender, they must show that disposals of radioactive waste have definitely ceased on or from the part of the site covered by their application, and that no further work in that part will be required for the site as a whole to meet our standards. We will not normally agree to partial release of a site if this leaves a number of physically separated parts of the original site still subject to radioactive substances regulation. Where contamination of ground or groundwater arising from the nuclear site extends beyond the boundary of the permitted area, these areas must be considered in the scope of the SWESC, and their contribution will be considered when determining applications for surrender. Records retention. Requirement R6 of the GRR concerns the preservation of knowledge and records at and after surrender. This requirement is covered in Module 7, entitled Other Management Requirements. However, this slide provides a brief summary of the main points. Before we grant the surrender of a permit, we will expect operators to demonstrate that arrangements have been put in place for the transfer, long-term safekeeping, and management of the records of the site by a suitable organisation. We will also expect operators to show that these arrangements can be and are being implemented. End of the technical training series. This module is the final module in the technical training. Congratulations on completing the GRR technical training. For further information about the GRR and its application, staff of any of the environment agencies should contact their head office Radioactive Substances Regulation team. Staff of any operator of a nuclear site should contact their environment agency regulator, and staff of any other organisation should contact the help desk of their environment agency and ask to be directed to the Radioactive Substances team. Thank you.